Dear friends, today I will discuss on a particular provision for getting mutual divorce, that is the 6 months statutory waiting period. Under section 13B of Hindu Marriage Act or under section 28 of the Special Marriage Act or under Indian Divorce Act, there is one 6 months statutory period. That means from the date of filing, the final hearing of the mutual divorce application can be conducted after expiry of 6 months. But at present, by virtue of various case laws, by virtue of different observations of the Honorable Supreme Court, the situation has slightly changed. I want to discuss the stage-wise development and the latest legal position for waiving of this statutory period. The first case law is on your screen. The Honorable Supreme Court in Sureshta Devi versus Om Prakash in the year 1992 explained that the intention of the cooling off period, that is the statutory waiting period 6 months, the intention of the cooling off period was to enable parties to reflect on their decision and attempt to resolve their differences. However, this cooling off period often contradicts the free will of the parties. Here, Supreme Court stated that the basic intention, the basic ideology behind this 6 months statutory waiting period is basically giving time to the parties so that it's an attempt so that their decision for divorce can be changed. If there is any possibility of any reconciliation, the statute, the lawmakers of our country try to utilize that opportunity so that if there is any remote chance of reconciliation, that can be utilized. But Supreme Court in the year 1992 observed that, however, this cooling period often contradicts the free will of the parties. The next judgment in the year 2004 in Navin Kohli versus Nelu Kohli, Supreme Court observed that where both the parties moved the court together to break a substance-less marriage, the cooling off period was unnecessary and an extraneous practice. In a case where both the parties are civil servant and just after 3 days of their marriage, they found that the marriage is absolutely a mismatch and they got separated. And after waiting of 1 year from the date of marriage, they filed application for mutual divorce, where both the parties, Supreme Court observed that where both the parties moved the court together to break a substance-less marriage, the cooling off period was unnecessary and an extraneous practice. Here, Supreme Court waived the 6 months statutory period with this particular observation. So, a little development is there regarding the 6 months statutory period. In the next landmark case, in the year 2017, Amardeep Singh versus Harvind Kaur. This is a landmark case. where the Honorable Supreme Court observed that the courts may waive the statutory period after considering the following. Now, in the year 2017, Supreme Court gave a clear observation that the 6 month statutory period may be waived based on certain conditions to be fulfilled. Condition number 1, whether the cooling off period has expired before submission of the first motion. First motion means filing of the case. And is there any separation of more than 6 months at the time of filing of the case? Whether the cooling off period has expired before the submission of the first motion. Number 2, condition number 2, whether all efforts for mediation, conciliation have failed and there is no likelihood of such efforts succeeding. The second condition is whether all the efforts for their reconciliation has been exhausted, and after this exhaustion of all the efforts, it is final that there is no chance of any reconciliation. Condition number 3, whether the parties have settled all their differences including alimony, child custody, etc. While waiving off the 6 month statutory period, the court has to consider, has to inquire that whether all the disputes like alimony, child custody, joint property, each and every point has been decided and settled by and between the parties. And the last one is whether the cooling off period will only prolong their agony. The last condition is whether this 6 months period will be of no help, but it will just create the mental pain and agony upon the contesting parties. If these conditions are fulfilled, as per Amardeep Singh judgment, 6 months waiting period may be waived off. This judgment was passed in the year 2017. And now the latest one, Amit Kumar versus Shuman Beniwal. The Honorable Supreme Court provided the exercise of discretion to waive the statutory waiting period of 6 months, jotting down the following factors to be considered. This judgment is exhaustive. This judgment gives clearly the points which are to be considered, and after consideration of these points, the learned court may utilize his discretionary power to waive off the 6 months statutory period. What are those conditions? How long the parties were married, the tenure of the marriage, how long they had stayed together, the period they are staying together and the period they are staying apart, how long they are stayed apart. Say a marriage took place 12 years ago, they stayed together for 2 years, and thereafter for the next 10 years they are living separately. So there is no hope of any reconciliation, because after 10 years separation there cannot be any kind of mental attachment between the parties, and it can be assumed that all the efforts for their reconciliation, for their reunion will be failed. And it can also be assumed that within this 10 years period when the parties were separated, there were several attempts for their reconciliation which were failed. How long their litigation had been pending, if there is any pending litigation, if there was any litigation between the parties during this separated period or since the date of marriage, how long the litigation continued. After continuation of 5 years or 10 years of matrimonial cases, there cannot be any expectation that there will be any reconciliation, because during continuation of these matrimonial cases for this entire period, there were several attempts for reconciliation by the family members of the party, by the friends and well-wishers of the party, by the lawyers of both the sides and the learned courts. In any matrimonial matter, the learned courts definitely try so that the parties may again unite. Existence of other proceedings between the parties, whether there is any pending case between the parties, that is to be considered. Possibility of reconciliation, if there is any possibility that the parties can reunite. Court will take into consideration this factor. This factor is most important because for the purpose of reconciliation, for the purpose of reunion, to avail the remote chance, if any, for their reunion, lawmakers purposefully made this provision of 6 months statutory period. So, court to ensure that there is no chance at all for their reconciliation. The next one, whether they had any children. It is to be considered. If they have any children, and if they have any children, who will be the physical custodian of the children? What about their maintenance? What about their well-beings? Because in a matrimonial dispute, not only the parties but the children are also get affected. So court will consider this particular matter also. And the last point is whether the parties had freely arrived at a settlement in relation to alimony, maintenance, child custody. Free will without any coercion, without any influence is required, and out of that free will the parties decided for this mutual divorce and they have settled the matter of alimony, matter of maintenance, maintenance for the children, maintenance for the wife or maintenance for the other spouse, child custody, child well-being, everything. Whether all sorts of things, all sorts of dispute have been resolved. So this is the latest Supreme Court observation for waiving of the 6 months statutory period. Nowadays, being a practitioner, I can say that if in any case I get any such situation, I get that these conditions are fulfilled, I filed application before the court for waiving of the 6 months statutory period, and after considering all these points with valid proof, sometimes court allows or court waived off the 6 months statutory period. So previously there was no scope for waiving off the statutory period of 6 months, but at present development of the law as per the needs of the society, to meet the demand of the society, to meet the demand of current days, Honorable Supreme Court permitted the waiving of the 6 months statutory period subject to fulfillment of the conditions. And it is the discretionary power of the learned court whether to allow the waiver or not. It is not mandate that 6 months must be waived off, but it is the discretion of the court, and the discretion should be exercised after considering the factors jotted down in Amit Kumar versus Shumon Benual case decided in the year 2021. So this is the present situation of law for waiving of the 6 months statutory period. I hope this particular episode will be helpful for the beginners who are just in the legal profession, who entered the legal profession as a fresher. At the same time, it will help the litigant parties also to know the latest legal position of mutual divorce, in particular the waiving of the statutory period. I receive many questions from different clients regarding the waive off of this statutory period. So I think this episode will be helpful for them also. I will come before you with my next episode with some new angle, new point, and till then, goodbye, stay blessed.